I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today we're back at it again, peeking our head into another compilation, and this compilation is going to be number 254. And I just want to say thank you guys for all of your support, everything that you've been doing for the channel. It has been amazing. And with that being said, don't forget to like, comment, and subscribe. Continue to do what you guys been doing because it has been helping the channel. Also, commentary will be left in the proceedings where there were commentary before, and chapters will be added for your convenience. Now, let's get to the stars of this particular compilation, the three judges' courtrooms that we will be in. First, we will be in the courtroom of Judge Richard Hillman out of the state of Michigan. Second, we will be in the courtroom of Judge Casey Brown out of the state of Colorado. And last but not least, we will be in the courtroom of Judge Matthew Sarber out of the state of Indiana. This is number 254. We are moving up the list. And listen, let's go ahead and check out this compilation.
Next matter is LVNV Funding LLC versus Ruth Conway, case number 244008GC. Is counsel here for the plaintiff?
Yes, Judge Hillman, Cezanne Barda.
Well, you're an attorney, sir?
Yes, sir.
Oh, okay. All right. I couldn't tell based on the way you're dressed. We do expect lawyers to wear ties and suits for court proceedings, Mr. Barda.
Yes, Your Honor. I completely apologize. There are two attorneys that handled our docket via Zoom today. Both failed to appear. I don't know why, and now I'm scrambling. I apologize.
Okay. All right. Is Ruth Conway present?
Yep.
Okay. Good afternoon. All right. So this is plaintiff's motion for summary disposition. Ms. Conway, the plaintiff filed a request to have a judgment granted in this matter. Mr. Barda, do you wish to proceed?
Yes, Your Honor. Our motion is based on MCR 2.116 C9 C10. We don't believe there's a genuine issue of material fact to move forward to trial. This is a straightforward collection matter whereby it was original creditor of Credit One Bank. LVNV purchased that, and all the chain of title and bill of sale documentation is attached to our motion. We also have billing statements showing charges made and payments made, which comports with the account stated theory in the state of Michigan. The address on those billing statement matches the same address where the proof of service went for this file. And we also have an affidavit from our client stating how much is owed at this time. Defendant not only failed to file a response to our motion for summary disposition, but also failed to file a counter affidavit, which is required by court rule. And even looking at her answer, all she states is she doesn't believe that this is her debt. I believe that plaintiff has provided proof and has established that this account was the defendant's, and I don't believe there's been there hasn't been a defense raised to be able to prevail at this time. Plaintiff respectfully requests that our motion for summary disposition be granted.
Okay. All right, Ms. Conway. So I have this motion for summary disposition that was filed by the plaintiff back on December 17th. I don't have any written response that was filed by you. I see you're holding up some kind of a receipt. I don't know what that's a receipt for, but we did receive your answer to the complaint. What date is on that receipt that you're holding up, ma'am?
October 29th.
Okay, so I think you're referring to your answer to the complaint that you filed in this matter, which was dated, let's see, which is dated October 28th. So I'm guessing that what you're holding up is verification that you filed an answer to the complaint. However, there was a motion for summary disposition. And basically
I
what
never got that. I
hang on,
never got that.
ma'am, hang on. You need to listen while the court's talking, and then I'll give you an opportunity to talk afterwards. So there was a motion for summary disposition. That's a request for a judgment, and it has an affidavit attached to it, and it has bills showing that you had a Credit One credit card and that you had made certain charges. It looks like there's charges to Meyer and Mason. There's charges to the city of Mason on the credit card,
Seriously.
Dollar Tree, and Celebration Cinema. And what the plaintiff has indicated is that that Credit One account was purchased by LVNV funding, the plaintiff in this case, and that based on the fact that you had used the credit card and you had made payments on the credit card under Michigan law, that's a cause of action for account stated, and you would have an obligation to file an affidavit indicating that those were not your charges and you did not have an account with Credit One, and you've not filed that. Is there anything you would like to tell the court, ma'am? This is the time for you to make your response.
Okay, I'm making this statement. I am here under duress. I have formally put in a formal complaint to the Consumers Finance Protection Bureau. I don't know who LVNV Funding is. I have never heard of them in my entire life. This law firm has done nothing but harass me with document after document. I had 3 collection agencies approach me on this matter. I contacted the other 2, told them exactly the same thing I told this firm, but this firm has continued to harass me. I have made that formal complaint to the Consumers Finance Protection. Whether they protect me or a loaning institute is another story. I am here under duress. I live on Social Security. I will be 69 years old in the fall, and I do not have a job. I do not work. I have 14 grandchildren. I'm a mother of 5, and 2 of them are veterans of the United States military. I help with my 14 grandchildren. So I don't have a job. I will collect Social Security.
Okay, let me ask you this. Did you have a credit card at Credit One?
I do not ever recall having a credit card from any place, and especially I would never have a credit card with a small amount of credit. In my past, whenever I had credit, it was a decent amount of money that I had on a credit card balance that I was allowed to borrow. That I get a phone call every other day. How do these people know I don't have Medicare B? How do they know that? I get harassed to buy Medicare B. I can't afford Medicare B. I live on Social Security. So how do I get them knowing I don't have it? You tell me.
Okay. All right. Anything further, Mr. Barta?
No, I would ask for our motion to be granted at this time, Your Honor.
Okay. All right. Well, Ms. Conway, we do have rules in lawsuits in terms of what's necessary to get past a summary disposition motion. You would have been required to file an affidavit verifying that you never had any credit card with Credit One, and that you were not the person that used this credit card that was in your name and made out to your address. And
Excuse me, but I was never asked. I was never asked by the court or received a document telling me I needed to do that. You're taking advantage of somebody that's not being represented by an attorney under maritime law. I'm representing myself under the power and the attorneys of Jesus Christ.
Okay. All right. Thank you, ma'am. So a summary disposition is granted for the plaintiff. And
I live on Social Security. I know federal law.
Ma'am, you need to stop talking while the court's talking. Mr. Barta, you can submit a judgment under the 7-day rule with the court. That's all for the record. Good luck, ma'am.
Thank you, Your Honor.
Good luck to you guys with Donald J. Trump. Maritime law is going bye-bye. You're going to have to all relearn constitutional law, thanks to MEGA and us anons.
.051 People versus Julio Soto. Entries of appearance, please.
Rafe Taylor on behalf of the people.
Good morning, Mr. Soto.
Morning.
We're scheduled this morning for appearance on bond. I believe this is Mr. Soto's first appearance before the court. Mr. Taylor.
Your Honor, I have a Rule 5 advisement and mandatory protection order. The defendant was unwilling to sign. If I may approach.
Yes, please. Thank you. All right, Mr. Soto, we're going to talk about a couple of these documents that we need to address for your first appearance this morning. I'll note for the record, Mr. Soto does appear out of custody and pro se, having posted an appearance bond on May 22nd. Mr. Soto, the first of these documents we need to address is this Rule 5 advisement under Rule 5C2. Did you have an opportunity to review this advisement?
I did.
All right. And do you understand each of the bulleted paragraphs on this page? All right. Well, I'm going to go ahead and explain them to you then. So the following is an advisement of your rights. Please listen carefully as these rights will pertain to you in your case. You have the right to remain silent and you do not need to say anything to anyone about the facts of your case. Any statement that you do make can and may be used against you unless it is something that you say to your own lawyer or a statement made to the district attorney while attempting to negotiate a plea agreement. You have a right to be represented by an attorney. If you cannot afford an attorney and you are considered indigent based on state guidelines, you may request that an attorney be appointed to represent you. If the public defender is appointed to represent you while you are in custody, which is obviously not the case here, then you are released from custody. You must then travel to the public defender's office and reapply if you wish to continue to have such representation. The district attorney represents the state of Colorado and does not represent you. The district attorney cannot give you legal advice. In most cases, you have the right to have a reasonable bail set. We may discuss bail today when your case is called. If you are a defendant on a victim's Bill of Rights case and bond has already been set by schedule or on a warrant, the bail cannot be discussed until the court can find compliance with the victim's Bill of Rights. If this applies to you, then your case would be set over expeditiously on the issue of bond to allow for compliance. You have the right to a speedy and public jury trial, or if the district attorney agrees, a trial to the court. You are presumed innocent, and if you plead not guilty, you have the right to require the district attorney to prove your guilt beyond a reasonable doubt. At trial, you have the right to cross-examine witnesses, the right to testify on your own behalf, the right to subpoena witnesses to testify on your behalf, and the right to appeal any rulings or decisions in the event of a conviction. If you are charged with a petty offense, you are entitled to a jury trial if, within 21 days after entry of a plea of not guilty, you make a request to the court for a jury trial in writing and tender to the court a jury fee of $25 unless the fee is waived by the judge because you are indigent. In petty offenses, you have a right to a jury of 3 unless a greater number not to exceed 6 is requested by you in the written jury demand. If you are alleged to have violated any law pursuant to Title 18 of the Colorado Revised Statutes, the law requires a mandatory protection order will enter against you. This protection order will state that you will not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the acts that you are charged with committing. And other conditions may also be ordered by the court as part of that protection order. Compliance with the mandatory protection order will be made a condition of any bond posted in your case. And if you fail to comply, your bond could be revoked or new charges could be filed against you, or contempt proceedings could result, or any combination of those events could occur. You may be able to resolve your case by plea agreement, but please keep in mind that any plea of guilty which you may enter may be, or rather must be, a voluntary plea and not the results of any threats, coercion, or undue influence on the part of anyone. Any agreements that you make with the district attorney must be in writing. After you have read these rights, you may have a conference with the district attorney to determine if you and the district attorney can reach an agreement regarding your case. This could be an opportunity for you to obtain more information about your case. You do not have to speak with the district attorney if you choose not to. And after you have been read this advisement, whether you choose to speak with the district attorney or not, your case will be called up by the court to either accept an agreement or set the matter for future court proceedings, such as motions, trial, appearance of counsel, or another setting. And so do you have any questions for me based on any of those advisements?
No, I don't.
Sir, have you ever served in the U.S. Armed Forces, or are you a veteran?
No.
I'm going to mark this form no. And I'm going to stamp this as reviewed with and acknowledged by Mr. Soto on the record today.
hold on. Do you say if I have any questions?
Yeah.
So under the Sixth Amendment of the United States Constitution, it grants me the right to know the nature of the cause of the action you are bringing against me, and grants me the court to the duty to tell me. I don't understand the nature of the cause of this action which has been brought to me.
So you're asking what the nature of the proceeding is?
Yeah.
We're going to get to that in just a moment when we talk about the charges that have been filed against you. In terms of your rights, do you have any other questions about those rights that I just read?
Like I said, I don't understand
What don't you understand?
the nature of the charges that you bring
Yeah,
against me.
we're going to discuss your charges in just a moment. But in terms of the advisement I just read to you, in terms of the rights we just discussed, do you have any questions about that?
No questions on that?
All right, I'm going to go ahead and stamp this as reviewed with and acknowledged by Mr. Soto on the record today. All right, the next order of business is the 4-count complaint and information. Sir, did you receive a copy of the 4-count complaint in this case? Has 4 charges on it?
I did.
Okay. And so you're asking about the nature of those charges? Is that the question?
Yeah.
Understood. So you're charged with 4 counts in this case. The top counts charged against you are, or the top count charged against you is a class 4 felony, assault in the second degree. That particular offense carries a maximum penalty of between 2 and 8 years in the Department of Corrections, a maximum fine of $500,000 and 3 years of mandatory parole. And that count alleges that on or about November 16th of 2025, you, Mr. Soto, with intent to cause bodily injury to another person, unlawfully and feloniously caused bodily injury to Salvador Rodriguez Gonzalez by means of a deadly weapon, namely a firearm. And so that is count 1. And I misspoke. Count 1 is punishable by 5 to 16 years in the Department of Corrections with that same fine and a mandatory period of parole. Count 2 is conspiracy to commit assault in the second degree. That is a class 5 felony, and it alleges that on or about November 16th of 2025, you, Mr. Soto, with the intent to promote or facilitate the commission of the crime of assault in the second degree, unlawfully and feloniously agreed with Transito Soto that one or more of you would engage in conduct which constituted that crime or an attempt to commit that crime, or agreed to aid the other person or persons in the planning or commission or attempted commission of that crime, and an overt act in pursuance of the conspiracy was committed by one or more of you. So that's count 2. Count 3 is felony menacing. That's a class 5 felony. It alleges that on that same date, November 16th, 2025, you, Mr. Soto, by any threat or physical action, unlawfully, feloniously, and knowingly placed or attempted to place Salvador Rodriguez Gonzalez in fear of imminent serious bodily injury by use of a firearm. Finally, count 4 is conspiracy to commit menacing. That's a class 6 felony, and it alleges that on or about November 16th, 2025, you, Mr. Soto, with the intent to promote or facilitate the commission of the crime of menacing, unlawfully and feloniously agreed with Transito Soto that one or more of you would engage in conduct which constituted that crime or an attempt to commit that crime, or you agreed to aid the other person or persons in the planning or commission or attempted commission of that crime, and an overt act in pursuance of the conspiracy was committed by one or more of you. So those are the 4 counts charged against you. Do you have any additional questions with respect to the nature of those counts?
Is this going to be a civil or a criminal action?
This is a criminal case.
Criminal? So there's 2 criminal jurisdictions in this constitution. There's 3 jurisdictions. If it's a civil, you must immediately dismiss this case.
We're not going to dismiss the case today, sir. Do you have any other questions?
So I move forward to dismissal for reason is because you are in the wrong court. I'm in the wrong court. They can bring the same case against me by the same judge.
All right. If you believe there's some kind of defect with respect to jurisdiction, you're welcome to file a pleading. I don't perceive any defect this morning. You're charged with a crime that occurred or is alleged to have occurred in Arapahoe County. This is a criminal court in Arapahoe County, and so the court finds adequate jurisdiction. But if you believe there's a jurisdictional defect, you're welcome to file a pleading. Do you have any additional questions about the nature of those 4 counts that were charged against you?
Okay, for the record, let the court show that the action in this criminal action, the conspiracy against the court to criminal jurisdiction to dismiss this case.
To the extent you're moving to dismiss the case, that motion is denied. Do you have any questions about the 4 counts that I just described to you?
At this point, no.
Okay. This mandatory protection order will contain some things that you'll need to require with or comply with as a condition of your bond. Do the people have any record or VRA record with respect to the protection order?
We do not, Your Honor. Thank you.
All right. And so, Mr. Soto, this order will name you as the restrained person. It will name Salvador Rodriguez Gonzalez as the protected person. The order does not involve a crime of domestic violence, but it does involve a Victims' Rights Act offense. And the order will contain the following terms. First, that you shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the acts that you are accused of committing. Second, you will vacate the home of the victims and witnesses and stay away from any location they are likely to be found. And third, you will not contact or have direct or indirect communication with the victims or witnesses. Beyond that, you will not possess, purchase, or control a firearm, other weapon, or ammunition. And finally, you will be restrained from Scooters Sports Bar and Grill at 13698 East Alameda Avenue in Aurora, Colorado. Do you understand each of the terms of this order?
No, I don't.
What do you understand?
Like I said, I don't understand the,
I'm not asking you about anything on those papers, sir. I'm asking you about what you don't understand about the terms of this protection order I just read to you.
I don't understand the nature of the charges that you're bringing against me.
I just asked you a moment ago if you had any additional questions about the charges. We've now moved on to the protection order. Do you have any questions about the terms of the protection order?
Have you seen a couple it's going to be under common law or?
No, this is statutory law that contains crimes that you are accused of committing. So this is a criminal case. It's based on a violation of statute. And those 4 counts that I just read to you are the counts that have been charged against you. With respect to the protection order and the terms that I just read to you, do you have any questions about those terms that you're required to comply with?
Is this right here under common law as you have?
I just answered that question, sir. This arises under statutory law.
The injured party under the common law, whereas the default, there's an injured party. So there's no injured party.
Yes, there is. The injured party is the individual who I read to you, Salvador Rodriguez Gonzalez. That is the alleged injured party.
I don't see no injured party here, so there's no evidence at all.
Mr. Soto, if you would like to file a pleading with respect to whatever you've got on your papers in front of you, you're welcome to do so. I'm not going to hear any more argument as to that this morning. Do you have any questions about the mandatory protection order?
No, I need to read it again.
I'm not going to read it again. Do you have any questions about the order?
No.
You're going to be required to comply with this order. I'm stamping this as reviewed with, acknowledged by you on the record today. If you violate this order, you will be held in contempt of court, or you may be charged with a new crime, which could be a misdemeanor or a felony. All right. Mr. Soto, do you have a plan for an attorney in this case? Do you intend to apply for a public defender or hire private counsel?
No, I'm going to represent myself.
You're going to represent yourself. All right. Well, I'm going to provide you with the Arguello advisement, which is the advisement that must be provided to an individual when they have indicated that they wish to represent themselves in a case such as this. So, sir, you have a right to have a lawyer, but you must prove to the court that you're working hard to find a lawyer. In this case, you're saying that you don't want one. And you can work hard to show the court that you are trying to find a lawyer by applying to the Arapahoe County Public Defender's Office. If you qualify based on your income level, you've indicated that you do not wish to do that. The other option is by hiring a private lawyer to represent you. You have indicated that you don't wish to do that either. And so ultimately, the court will treat that as giving up your right to a lawyer this morning. You've indicated that you wish to proceed pro se and represent yourself. The highest charged against you is a class 4 felony, second degree assault with a deadly weapon. I'm just going to fill out this form. I'll be back with you in just a moment. All right. As I mentioned previously, assault in the second degree with a deadly weapon is the top count charged against you. That's a class 4 felony. It carries a maximum sentence of 5 to 16 years in the Department of Corrections and a maximum fine of $500,000. And so I have a couple of questions for you. What was the last year of school or education you completed?
No comment on that.
What was the last year of school you completed, sir? Do you have any legal training?
Legal what?
Legal training?
Don't know that question.
That's a no?
I don't know that question.
Okay. I'll take that as a no. Do you understand that the criminal law is a complicated area and that having a lawyer trained in this field could be of great help in preparing and representing you in your defense? No.
Can you repeat it?
Do you understand that the criminal law is a complicated area and that having a lawyer trained in this field could be of great help in preparing and representing you in your defense?
Yeah, I don't need one.
Okay. I'm going to mark the form no. Finally, sir, you will go on to the next step of this case without a lawyer. You will take a serious risk that you will not present your case well, including risking your right to cross-examine witnesses and address those witnesses against you, risking your right to have someone testify for you, even if they do not want to by way of a subpoena, and risking your right to remain silent since anything you say can be used against you. And so ultimately, with respect to your decision to represent yourself this morning, are you under the influence of any drug, alcohol, or medication that's affecting your decision?
No.
All right. Mr. Taylor, what I'm going to do is ask you to approach, and Mr. Soto, I'm going to have you sign this document that you have decided to proceed pro se. Your Honor, if I may approach? Yes, please. Thank you. All right. And apart from setting this matter for preliminary hearing, are there any other issues from the people this morning?
No, Your Honor. Thank you.
All right. Let's go ahead and set for a preliminary hearing from the people. Are there any dates you'd like to propose? All right. June 25th, 1:30 p.m. for preliminary hearing. Mr. Soto, we will print you off a setting slip that'll have that next hearing date on it, June 25th at 1:30 p.m. And we will see you back here then. Your bond will be continued through the preliminary hearing date. Have a good day, sir.
As well.
Ready on Mr. Madrid's case?
Is the one individual unable to stand or?
Yeah, I got a bad hip.
Thank you. Do you swear or affirm under the pains and penalties of perjury to tell the truth, the whole truth, and nothing but the truth, so help you God?
Do.
Thank you. You can all have a seat. I need Mr. Heights to come on up to the front. Sit there, sir. Mr. Heights, can you please state your full name?
My full name is Jack Lewis Heights.
Thank you.
Capital,
what is your date of birth?
Capital J, lowercase a, lowercase c, lowercase k, capital L, capital H, lowercase e, lowercase I, lowercase t, lowercase z.
What is your date of birth? Thank you, sir. Do you have a copy of the information in front of you?
Yes, whatever information I was given, yes.
You should have two documents, the initial hearing order and the information. And the information is the document that is a single page titled Information in the upper third in all bold and all caps. It reads as follows, that you are alleged to have committed on January 14, 2025 here in Marshall County, state of Indiana, one count of auto theft, a level 6 felony where it's alleged you did knowingly or intentionally exert unauthorized control over a blue 1997 GMC Sierra, the motor vehicle of Daniel Cervantes Quintes, with the intent to deprive the same individual of the vehicle's value or use. Now, Mr. Heights, I'm not asking that you agree or disagree that you committed that offense, but do you understand what it is that the state is alleging?
No, I don't.
In what regard don't you understand?
I've never been in Marshall County ever in my life, so I don't understand how I could have exerted control over a vehicle in Marshall County. I was simply riding in a vehicle in St. Joe County, which is St. Joe County jurisdiction.
Mr. Heights,
if I was,
Mr.
so
Heights,
I don't understand the nature of the charge, no.
Mr. Heights, I want to point out again, as my question was clearly worded, I was not asking whether you agreed or disagreed with the charge. I was just asking whether you understood what the state was alleging. And to do you one additional favor, I will read you the statutory offense for auto theft. If you just give me a moment, that should clarify what the state is alleging. And certainly I'm presuming that you're innocent of the charge, as I indicated to you. And so therefore the not guilty plea will be entered on your behalf. And then we can move this case forward to some hearing dates as well as potential trial if you are disputing the charge ultimately after discussing with your attorney. So give me one moment, sir. Statutory offense of theft as charged by the state reads as follows. A person who knowingly or intentionally exerts unauthorized control over the property of another person with the intent to deprive the other person of any part of the use or value of the property commits theft, a Class A misdemeanor. However, the offense is a level 6 felony if the property is a motor vehicle, and that is under Indiana Code 354342, subsection A1B, Romanet 1. Does that help you understand what the state is alleging?
No, sir, I don't understand that. I was never in possession of this vehicle. I was just riding in it. I was just a passenger in it.
And it sounds as though you're disputing the charge, but what portion?
I'm not disputing. I'm saying I don't understand the nature of the charge. I was never in Marshall County. I was never in possession of this vehicle. I was just a passenger. I was never questioned during the course of when this vehicle was in a snow ditch. I was just helping somebody push the vehicle out of the snow ditch. No police never asked me any questions about it. I was never informed of anything at the time. I was sent to the hospital because I was hypothermic, helping somebody push a vehicle out of a snow ditch. I've never been in possession of this vehicle at any point.
All right, Mr. Heights.
I don't understand any of that.
I appreciate that, sir. Here's what I'm going to do. For the jail staff, I'm going to have Mr. Heights have a seat in the back. I'm going to conduct the other initial hearings, give him a moment to read the information more thoroughly. I encourage you to read over the initial hearing order as well, Mr. Heights. And then you and I will have a discussion after I've concluded the other two initial hearings about your initial hearings moving forward.
Yes,
Thank
sir.
you. We'll stand in recess in this case. Mr. Looney, can you come on up to the front? Okay. Mr. Heights, come on up, sir. This is again 50D032605 F6107, State of Indiana v. Jack Heights. He's back present with us, and I recessed Mr. Heights' case because he wanted, or I should say, I was going to give it an opportunity to review the information in the case to make sure that he was understanding what the court was asking as well as the nature of the charges. And I just want to refresh some of your recollection, Mr. Heights, in the sense that first, I place you under oath at the beginning of these proceedings and you remain subject to that oath. Second, I am presuming that you're innocent of these charges and entering a not guilty plea on your behalf. Third, today's hearing is largely procedural in nature, and so it is not necessarily about the disputed facts of the case. The state is not presenting any evidence of your guilt. They have not made any statements asserting that in any way. The court has only found a probable cause determination to essentially hold you now, and I was going to address that with you at the conclusion of your case of what your bond would be. And so the reason I raise that is that you are presumed innocent of these charges. There is no need to make any factual assertions about the case because today's hearing is not a hearing where factual assertions will be made. And then finally, to that point directly, because you're under oath, any statements you make here today could be used against you. And so if there's any sort of statements that you unintentionally make or intentionally make that could be construed as incriminating, they could be used against you. Mr. Heights, do you hear that recitation that I just provided to you?
I heard you, yes.
And as I indicated, we were at the stage where I was going over the information in your case. Do you still have a copy of that in front of you, sir?
I do.
And it charges that one count of auto theft, which I'm presuming you're innocent of, entering that not guilty plea. But the main question I have for you is there is a statutory charge that the state has filed this under. I recognize that you dispute that charge and do not believe you committed that offense. And I'm not saying that you did, nor am I finding that you did, but I'm just trying to make sure that you understand that the state is alleging an auto theft charge and what that charge entails. Does that help you understand what I'm asking?
No, sir. I don't understand that. Marshall County is stating that I was in possession of a vehicle where I was in a vehicle in St. Joe County. Marshall County has no jurisdiction on what happens in St. Joe County. So if Marshall County is saying that they have irrefutable evidence proving that I took the vehicle, or eyewitness testimony saying that I took the vehicle from Marshall County, is one thing. But to say that Marshall County is alleging that I was in possession of something that was stolen out of Marshall County in St. Joe County, that's not Marshall County's jurisdiction. That's St. Joe County's jurisdiction. So therefore, I don't understand the nature of the charges being out of Marshall County. It should have been out of St. Joe County. Do you understand that?
I understand what you're saying. You're essentially mounting a defense here today, which I've tried to explain to you is a factual.
No, I'm not mounting a defense, Your Honor. I'm simply stating the facts of the situation as it's presented to me on paper. How does Marshall County charge me with possession of something where I wasn't even in Marshall County when I was found as an occupant in a vehicle?
Well, the mechanics of the charge is that they review a investigative report. They then prepare the information. They also then submit it an affidavit of probable cause from the investigating officer in the case. That affidavit of probable cause was submitted to the court on April 23rd, 2025, filed in the court the day that the information was filed. There was an order finding probable cause signed by one of the judicial officers here in Marshall County that set your bond, as well as found probable cause for the offense of auto theft.
Who found probable cause of auto theft, though? I don't understand. I wasn't in Marshall County. There's no evidence to prove that I was in Marshall County ever in my life. I was an occupant in a vehicle in St. Joe County, and nobody ever asked me any questions. This case is 1.5 years old. I'm the one that contacted Marshall County when I found out about the case to try to clarify the situation. I'm the one that tried to rectify everything. I would like to know who gave probable cause to charge me. Was it a grand jury? I have a constitutional right to a grand jury. I feel like the prosecutors have used their discretion in charging me with a crime that didn't even occur in their county, that they can't even show that I was even in their county. They have no irrefutable evidence showing that I was ever in Marshall County. I was pulled over, not even pulled over, I was pulled up on by an officer pushing a vehicle out of a snow ditch in St. Joe County. That's not possession of an automobile. That's not possession of, that's not theft in any way. So therefore, I don't understand the nature of being charged with a theft when I was never in Marshall County. And there's no evidence that can ever state that I was in Marshall County. There's no video evidence. There's no eyewitness testimony that's ever going to put me in Marshall County stealing anything.
Let me ask you this, Mr. Heights. Do you know what theft is?
Yeah, theft, I'm assuming, is taking somebody else's property.
Correct. I read it to you earlier about the exerting unauthorized control over the property of another.
I wasn't in control of this property.
And I didn't, that was not my question. Do you also know what a motor vehicle is?
I know what an automobile is, yes.
And so
a motor vehicle is a commercial vehicle used for commercial purposes on the highway.
I didn't say commercial motor vehicle. I just simply said motor vehicle. But
motor vehicle, by definition of Black's Law Dictionary, is a commercial vehicle used for commercial purposes on the roadways.
And so you know what theft is, you know what a motor vehicle is. And so if you combine those two, you understand what theft of a motor vehicle is. Is that fair to say?
No, I'm not understanding how I'm being charged with theft of a motor vehicle.
Again, that was not my question. I just putting all this together and just simply logicking through this. You understand what
you're arguing? Semantics, Your Honor. You're arguing semantics is what you're doing. I'm telling you that I was never in Marshall County, and there's no evidence that can ever put me in Marshall County. I've never been here. I've never been to the city of Bremen ever in my life. So how did I steal a vehicle? I think I was incarcerated in St. Joe County Jail, as a matter of fact, at the time of this incident.
Mr. Heights, let me ask you this. Do you understand that we can get through this hearing today and we can go over your rights and we can go over your attorney status and we can then certainly assert your innocence as you're doing? Or
can we go over my right to a fast and speedy trial? Can we go over that?
I'm trying to get through understanding that you know what your rights are, but we haven't got to that point yet. My question is, do you understand we can go through those things? Or if you simply can't answer yes or no to certain questions, we can recess the hearing and I'll call you back tomorrow and we can bring you in tomorrow to go over this hearing. It's your choice, Mr. Height.
That's not going to change my understanding of the fact that I've never been in Marshall County ever in my life.
And
how I'm being charged with a crime for being in Marshall County, and I've never been here. I was not pulled over in a vehicle. I was an occupant in a vehicle in St. Joe County. So that's St. Joe County's jurisdiction if they choose to charge me with possession of a stolen vehicle. You're charging me with theft of a stolen vehicle, meaning that I was in Marshall County and stole the vehicle from Marshall County. Unless the state's saying they have irrefutable evidence, video evidence, or an eyewitness testimony placing me in Marshall County, then what probable cause did they use to even charge me? They're abusing their discretion. It should have went through a grand jury. I wouldn't be indicted on a charge through a grand jury with this type of evidence. Ever. That's my constitutional right, to a grand jury. The prosecutor is abusing their discretion. They're going off of information that's not true. I have never in my life been in Marshall County, ever in my life. Have definitely never been to the city of Bremen. So unless the prosecutor sent under oath that they have eyewitness testimony or video evidence placing my face in the proximity of this vehicle in Marshall County, me being pulled over in St. Joe County, not even pulled over, but pulled up on, pushing a vehicle out of a snowbank for somebody, is not theft of a motor vehicle.
Thank you for your opinions, Mr. Heights here. And what I'm going to do is find that the defendant is unwilling to go forward with answering questions here.
You're asking me if I understand the nature of this cause, and I'm telling you that I do not understand the nature of this cause.
Well,
how can I understand the nature of being charged with an auto theft from a county that I was never in, that they cannot prove that I was ever in, that I was not, that the vehicle was not even found in Marshall County? This should be under St. Joe County's jurisdiction, not Marshall County's jurisdiction. I'm arguing subject matter jurisdiction. I'm arguing subject matter jurisdiction. I apologize. I don't mean to interrupt you, Your Honor. I'm just a little frustrated here.
I completely understand that. I'm going to give you 24 hours to cool down and think about it. So we'll recess the hearing. I'll see you tomorrow. You remain subject to the bond previously set.
All right.
Thank you for the jail staff as well.
So you guys all ready to?
I'm not threatening you. Say one more word and that's 30 days. 30 days.